My name is Russell Barnier. My practice is Barnier Law. I'm a commercial lawyer, sole practitioner in Lockwood South, which is 18k southwest of Bendigo. I've been involved in commercial law for, dare I say, 35 years or so, thereabouts. And my roles have been corporate general counsel and also corporate secretary. So, the purpose of today and the purpose of a restraint of trade clause is clearly to protect the buyer. I'm dealing with, in this instance, commercial purchase of business between a company or a person who's an individual but buying through a company and a company who is selling. So in order to protect the buyer, what do restraint clauses do? They maintain the value of goodwill paid in the purchase price. I'm not going to get into how you calculate goodwill because there's 1,000 ways of doing it, and there's even questions on when it's worth the money that is allocated to it. It prevents the vendor opening up a competing business, either nearby or too soon after the settlement, and it prevents the vendor hiring back critical staff to a competing new or existing business that they set up. So there's 5 elements that I want to talk about today. The first is the legal basis. And with commercial agreements, it is actually a contractual agreement. And although the courts have a view that restraint of trade clauses are against public policy, because effectively it's stopping somebody from trading and using their expertise, which they've grown through their life, to earn a quid. So it's not a flavour of the month action. Define the vendor prohibitions. Now, you need to be fairly clear here, because as Rosa said, the courts are not favourable towards restraint of trade clauses generally, so they won't take a favourable view if it's unreasonable. So if you're setting up a new business to continue to provide the same service for a period of time, you don't want them setting up the same service, you don't want them doing it for a certain amount of time, and you don't want them doing it down the road from you, because clearly it's going to take your customers. Another prohibition is against soliciting, enticing customers, suppliers, or employees to follow them to the new business. Now, damages is another issue. That's the third element. If you can't quantify your damages, the court is not generally going to do it for you, because it's not putting itself in the position of saying, well, if you can't tell me what you want as a restraint of trade result, then I'm not going to tell you what you can achieve. They don't do it. It doesn't work that way. So it doesn't prevent a person from making a living. And as I mentioned before, the restraint of trade clauses, the purpose is not to make somebody unable to make a living and use their trade. That's not its purpose. Its purpose is to protect essentially your goodwill in the commercial sense from it being downgraded by somebody's activity who either worked for you or sold you the business.
Last question.
Sure.
Sorry. You're never coming again.
Now, I do reserve the right not to answer it. Okay. The other one is, another element is what you're claiming and is the restriction in your contract reasonable? Because if it's not reasonable, the court is going to find against you. If it's reasonable, you have a better chance of succeeding. And we'll talk about that later. And enforcement of defined damages. Again, if you come to the court without knowing what it is that you are seeking, but saying, oh, I've lost money over this transaction, he sold me the business and went off and started down the street, it's caused me loss, I'm looking to the courts to recover my loss. That's not going to work unless you can quantify what your loss is. Now, do you want to ask your question? Because I'm going on to
perhaps, yeah, in a way it was perhaps I've answered it beforehand.
Oh, good.
I was thinking, well, so let's just say that I leave Rosa and all my clients, we had a restraint of trade clause, but all my clients are very strong restraint of trade clause. All my clients love me so much, they can't say, Bet, I haven't asked them. They say, Bet, we want to love you so much, we want to come with you. So
you can deal with that, and I'll talk about that later, because, and it gets into how to entice them. But there's 2 things that you need to take into cognizance here. And the first is you had dealings with them in the 12 months before you left, and they have engaged you and paid you money for services the same that you were providing to the employer. So on those 2 bases, that can be covered in your agreement.
And it is.
Yeah, that's right. So I'm going to work through an example here. So in this instance, the business, it's a posh French chicken restaurant. The purchaser is a winner of MasterChef Australia, and he's formed a new company to buy this restaurant. That's him. That's him. Yeah, keen as mustard. Now, the restaurant is called Le Poulet Ingénu. And the reasons for purchasing this restaurant is it has an excellent reputation for food and for service. It has 100 covers, so it's not huge, but it's not small either. And it has regular diners. The chef is retiring. Now, he's just retiring for reasons of his own, but I kind of guess what they might be. Having difficulty getting the ingredients right. But another thing is that all the staff, they're willing to stay on in the business that's being sold, which is terrific. The business also has unique and sought after chicken dishes, including poulet ingénu. So it's a specialty restaurant, as you can tell. But most importantly, it's important to know that the purchase price also included an exclusive license of the chef's IP in his recent cookbook, which is 50 Shades of Chicken. But then what happens? What happens after settlement day? He opens a new restaurant. It's called Le Poulet Grande with his cousin. He's a young slip of a man, a lot younger. He continues to cook using the recipes from his cookbook. And he entices his best kitchen hands to join him and creates new and exciting dishes in the same genre that he did in the previous restaurant. This is his new dish, and he's named it Voulez-vous coucher avec moi? Yeah. So, same old story. He's just recreated his restaurant at a new location. So, I'm not giving you the address in case you want to go and cause my client more loss. So where does the purchaser stand? What's the legal basis for any recovery that he might have? Well, it was a contract for the sale of business. The contract included restraint of trade clauses. Now, interestingly enough, the standard LIV contract, which is the Law Institute Victoria contract, it does include restraint of trade provisions. They're basic, but they are there. So it's at least acknowledged that even in a standard contract, there's the ability to restrain trade after settlement date. But what you can do is there's a provision, of course, in the LIV contract for including special provisions, and you can change the restraint clauses by inserting contrary clauses in your special provisions, which will take precedence. Now,
everybody, how you can vary the contract.
With very innocent and very clear and precise legal speak. But you need to define the vendor prohibitions in your special conditions. You need certainty, as any lawyer will tell you. So, okay, you include a non-compete clause. Now, I'll just read this one out because I think it's important. And this is just an example, and I'm not saying to you that this is watertight. I'm saying this is an example of something that you might consider. The vendor must not, during the restraint period and within the restraint area, be concerned in any capacity, either directly or indirectly, in any other business or business activity which may, in terms of product, service, or nature, compete with or damage the business, except with written consent of the purchaser, the business being the one that's just sold. So that's your non-compete clause. Then you have a non-solicitation clause. And again, this is an example, and I'm not saying that it's watertight. The vendor undertakes, because you'll only ever know if it's watertight if it's tested in court. So the vendor undertakes that the vendor on its own account or for any person, enterprise, firm, trust, joint venture or syndicate will not directly or indirectly during the restraint period and within the restraint area solicit, approach or entice away any client of the business with whom the vendor has had direct contact within the 12 months immediately following settlement.
Russell.
Yes.
So there's no yes. It infers dealing. It doesn't say the word dealing.
No, not yet. Wait for it. Yes. Also, will not employ or engage any employee of the business with whom the vendor has had direct contact at any time during the 12 months immediately prior to settlement. And also, they won't prepare, issue or participate in any circulars, letters or advertisements, or divulge to any person any information, including but not limited to confidential information concerning the business. Now, in this particular example that I gave you, confidential information was defined. It was a defined term within special conditions, and it included the recipes for special dishes, such as this one, which was a big seller, and that's poulet de velours. So you understand that there's a lot of IP in the recipes, and there's a lot of goodwill in the types of dishes that were being served. People would come for miles. So you get down to the restraint period, and we were talking about cascade clauses before. And you might not like them or you might like them, but they do serve a purpose. So nothing is set in stone as far as your calculation of the periods are concerned. It really comes back to what type of industry you're in, what the competition is like, what the revenue is like, what your client base is like. All sorts of factors go into this. But you will see in the cascade, you start off with a bigger figure and you end up with a lower one. Now, somewhere along the line, one of these is going to be reasonable as you go down. And the reason that they're cascading, as we discussed earlier, is that if the guy does go off in our example and starts another restaurant and takes away the custom, how many years should it take for the person who bought the business to either build up clientele enough that he's no longer suffering, and the new business is no longer taking clients? Would it be 5 years? That in this instance is way too long. 2 years? That could be too long as well. 6 months might be reasonable, but you don't know until you try to enforce it. And the difficulty of trying to enforce it, and I'll talk about that in a minute, is that your first line of defense is your solicitor's letter. And your contract will say, in the way it's worded, that you will not open up a business during the period of 5 years from settlement. Now, you've said 5 years, but it's said in terms of 5 years, or if the court doesn't accept 5 years, then 2 years. Or if the court doesn't accept 2 years, then 1 year. Or if the court doesn't accept 1 year, then 6 months. But your solicitor's letter, which of these periods is it going to start with? And this is why, of course, you would start with the most, the longest, which is 5 years. But is that reasonable? If it's unreasonable, the person that you're sending the letter to is going to say, no way are we going to do that. That's 5 years. You won't even get anywhere near a court if you're going to say 5 years. So you've got to be certain that when you list your cascading periods, the first one that you list should be reasonable as well, and then cascading downward. In the case of a clause I've just came across not long ago, 10 years. I mean, how ridiculous is that?
How long was it?
10 years.
10 years.
Yes. Not a snowball's chance, where to get that enforced by a court. And the restraint area, 50 kilometres from Indigo CBD, 25, 10, 5. I mean, 50 kilometres is going to take you past Castlemaine. Is it fair to restrict somebody to not open up a competing business in Castlemaine if you're in Bendigo? You could argue that it's a completely different crowd. I mean, Castlemaine people tend not to go out for dinner anyway. And the other thing too is, what are your quantifiable damages? The parties, and this is really interesting, because the parties to the contract can anticipate an appropriate compensation for loss to the purchaser resulting from a breach of the restraint clause by the vendor. Now, because you've got two competing businesses, and two competing businesses have two competing lawyers, you're virtually you're deigned to be at an equal level as far as consultation is concerned. So some examples, depending on the type of breach, and you need to keep that in mind. Not all breaches are the same. Not all business contracts for sale are the same. Not all businesses are the same. So some examples. The sum, this is trying to quantify your damage. The sum equal to 100% of the annual average gross income derived by the purchaser over the 2 years preceding settlement. That's when they were working to the vendor, clearly. And then it would go on to say if they worked for less than 2 years, there'd be a way of extrapolating it out. But I did see a clause in a contract recently that said 120% of the annual gross income. Now, is that a penalty, or is that a valid assessment of what your damages might be that you suffer?
Russ, can you talk about why penalty is a problem?
A penalty is a problem because the court's very reluctant to impose a penalty. To enforce the imposition of a penalty. Very reluctant. And you come back to, well, the basic context is that the whole thing's against public policy anyway. So they're not going to consider something that's particularly adverse to any one of the parties, because that's not where they're coming from. So 120%, to me, that was a penalty. And yet, the clause went on to say, or another subclause, said that the two parties considered what might be an appropriate calculation of the loss and considered that this was in fact appropriate and didn't constitute a penalty. Now, while that's in the contract, you can say anything in a contract and it can be right or wrong. And it's not going to be determined if it's right or wrong until the court says so.
That's like I was saying earlier.
Indeed.
You put a restraint here and you
Yes.
say, this is what I want.
Yes.
And the court's going to agree with that.
Absolutely. That's correct. And that's why you have bargaining power, or at least the ability to bargain your restraint of trade clauses. So, okay, the next one. This is still calculating the amount of damages. The amount received during the restraint period, so that might be the 5 years, might be the 3, might be the 2, by the vendor from providing services similar to the business to individuals or entities the vendor interacted with as clients of the business during the year prior to settlement. So in our case, it would be major clients, corporate clients, because they're identifiable, continual bookings, they're identifiable. And another one, 75% of the amount by which the total of the average monthly takings of the business over the restraint period were less than the vendor's takings from the business over the same period prior to settlement. Now, I'm not saying again that this is a clause that the court has determined, because to my knowledge it hasn't. But the attempt here is to say, okay, you've started up a new business, you've taken most of my clients, you've gained some of your own, that's fine. But 75% as an innocent indication of your income would have been earned from people that would have come to my restaurant as the purchaser if you hadn't started up. So it could be 75%, it could be 50%, it could be 25%. But the important thing is you have tried to work out beforehand a reasonable calculation for damages. D, the amount paid to obtain suitable replacement staff and the wages to the point in time when experience equals that of the departed staff member. Now, Rosa mentioned this a little bit earlier, because there's always a cost in losing staff, there's a cost in replacing staff, and there's a cost for educating staff. So if you anticipate all of that, it could be validly included in your restraint of trade damages calculation. So reasonableness, and this is really overriding everything. What's reasonable and what's not. So the basic premise is that the court doesn't like restraint clauses because they are considered to be against public policy and will only enforce what it considers to be reasonable in the circumstances. So the factors that you need to consider as to whether something is reasonable or not is, first, what's the nature of the business? So in this particular case, it's a restaurant, Le Poulet Ingénu. It has specialty dishes. It has a good reputation. People come for miles for their specialty dishes, and it has 100 covers, which is a great size. It's not too big. You don't need a huge kitchen, and it's not too small, so you don't make money if it's too small. The existing premises were pretty elegant, and as we said, it had an established and regular clientele. So, is the goodwill a significant part of that purchase price? Well, yeah. Look what you're buying. You're buying a great location with return business, people coming back, the reputation for quality and innovation, continuing staff, and regular significant income. All this will be factored as part of goodwill into your purchase price, and that's what you want to protect. So will goodwill significantly be impacted by the vendor's actions? Well, competing business opens locally. Same well-known chef cooking familiar recipes. Poaching experienced staff. A decrease in the diners and reduced overall takings from the business that was purchased. goodwill is significantly impacted. And the standing of the parties, because this is a commercial transaction evidenced by contract, the level of contractual understanding in commercial agreements is deemed to be higher because the parties are deemed to negotiate on more of an equal level than an employee-employer situation where the employee says, well, if I don't like it, what happens? And the employer says, well, you don't get the job. So it's not the same bargaining power. Equality in negotiating restraint terms, same deal. Damages represent a fair and appropriate assessment of potential loss and are not intended as a penalty. We touched on this earlier. The courts won't effectively condone a penalty in this situation. An equal opportunity to seek legal advice. Businesses, by nature of their business, need legal advice. They need legal advisors, and it's accepted that people in business understand this and take legal advice when they can. So get your lawyers to negotiate your clauses for you if you have a commercial contract. Let them fight it out.
That's what happened in that where they had struck out those two.
Exactly.
The lawyers negotiated.
Yes.
And to the detriment of our clients.
Yes.
And knocked out those two vendors.
Correct. Yeah. Now, if your client considers it was so significantly to his detriment, is there a negligence action against the solicitor? Just query.
They didn't know us at that point.
Right. Yeah. Well, that's it. Rosa was saying that they didn't know we existed at that point in time. Yeah.
We used to establish the experience as a potential employee where I actually was offered a job and I actually turned it down, and the CEO said to me, "You will never work anywhere else other than you can work here." So there was that direct threat to me to accept a job rather than work anywhere else. Where does a person stand in that?
Well, you see, that's not. No, we're not here. I'm going to deflect that one solely because it's not part of the contractual agreement with restraint of trade, and that's what we're dealing with tonight. Yeah.
Okay.
Yeah. Okay, moving on. So enforcement. If all these things happen to you, what's your first line of well, not defence, but your first aggressive contact? It's a solicitor's letter. So you go off to your lawyer, you go off to Rosa, and she'll say, okay, give me the facts. This is what we'll say in our letter. We'll lay out the breach of contract, list it. We'll reiterate the agreed physical restraints in terms of time and proximity. We'll reiterate the agreed relevant damages calculation, which was set out in the contract and negotiated. And we'll set a date for compliance, as in 14 days, 21 days, whatever. An immediate cease and desist clause to say, you stop doing this now or we'll take you to the cleaners, threatening an injunction. So, to the courts. First off, if they ignore your letter, which they will, because if your restraint period and location are going to be so excessive because that's the first one you chose, they're going to say, get nicked. It ain't going to work. You're not going to be able to enforce that. So again, if you have your solicitor's letter and you want to make the first salvo across their bows, you've said in the contract that you will start with the first restraint period and first restraint clause, because that's what you say is applicable, unless the court strikes the others out. So you need to have a reasonable figure in your period and in your,
So you're saying don't start with the top one?
No, you need to start with the top one because that's what your agreement says. And they only cascade in case the courts don't accept the first one because it's unreasonable. But you would start with the first in your solicitor's letter. But the more unreasonable it's considered to be, the less likely the opposite side are going to say, oh, yes, I understand that I've done all these wrong things and I'll pay you the amount of damages you require. They'll say, get nicked, because they'll know that you can't enforce it because it's so totally unreasonable. So this is why...
Horrible chess game.
Well, it is a cheats game, you're right, and we'll get to that as well.
So there's that argument for making sure that when you're negotiating the contract, that you start off with what you think is reasonable.
Well, there's two bases here. If you want to start, I'll start that again. if you're the purchaser, you would want to start out with something that's reasonable. If you're the vendor, you'd want to start with something unreasonable because it won't apply. It'll go down the tree until the court finds that something is reasonable. So you're better off as a vendor saying, yeah, 10 years, let's do 10 years, but you'll never enforce it. Okay, so to get injunctive relief, and I don't know whether any of you have been involved in getting injunctive relief, you have to show a realistic case, a chance of winning the case, and that the injury to the plaintiff outweighs the injury to the defendant. So Rosa was saying before, you need to go with clean hands. Usually taken out after proceedings commence, but not always. You can get urgent interim injunctions issued on an ex parte application where there's no defence appearing before an action is commenced. But they're of limited duration, and the purpose really is to stop something happening straight away in order to encourage the appropriate legal action taking place. So you get to the court. The court will determine the appropriateness of the action and interpret the wording of the clause. Are the actions to be restrained well defined? Do you know what you're claiming? Okay, you know what you're claiming. Are they too broad? Is the area or the time period reasonable? And we've talked about cascading definitions. Is the agreed damages calculation acceptable, or is it a penalty? 110% of earnings, clearly a penalty in my mind. Were the parties matched in negotiation understanding? Well, they both had lawyers. And the potential finding, well, sometimes it helps and sometimes it may not. But the potential finding, okay, the vendor opens substantially the same business, okay, cooks substantially the same dishes and engages staff from the sold business, knowingly serves customers, including corporate clients, of the sold business. It has a severe impact on the sold business. It decreases the clientele, decreases revenue as a result of that, and the cost of replacement staff from the people that were taken has been significant. And of course, when they got there, they didn't know what they were doing. So the end result of all that was that damages and costs were awarded to the purchaser.
Is that an actual case?
That's justice prevailing.
That's an actual case.
It could be.
I just want to know when you get
Yeah. And then I'll just raise, I put this screen on here because this is the Victorian Supreme Court. And a lot of you might not know, or some of you probably will, but when the court was built, that statue of justice that you see at the top here was unique in the world because it was the first sitting statue of a statue of justice. There you go.
No, Russell.
Yeah. It might not be now, but when it was erected, it was. There we go.
So I'm negotiating my contract.
Mm-hmm. What are you? Are you a company or are you an employee?
Oh, yeah, a company.
You're a company. Are you buying or selling?
I'm going to buy Rose's business.
I'm going to retire.
Have you spoken with your accountant?
Logan giggles. Yes. And then when we're looking at the damages, my understanding here was that you're saying that part of the contract, I'm going to look at the restraint and look at the damages. We're trying to quantify.
Yes.
And
Yes.
trying to assess how damages will be.
Yes.
So let's just say that we do our best. It's not always, you try and come up with the best way that you can of how, but then, 5 years down the track, no, not 5 years, but, sort of before we negotiate the contract goes, the sale goes through, and then Rosa sets up her business next door to mine, and I smash you. And I've established or I've experienced some sort of loss that's not quantifiable, that I haven't.
No, but you can cover that in terms of if you have a restraint period that you've agreed on, and say it's 12 months, realistically, say it's 12 months, then in calculating your damages, you could say, and you both could agree on, whether Rosa does or not is another matter, but you would put this up as part of the term, is that you would be entitled to the receipts of legal services that she provided to clients of her former business.
Is that an account of profit?
Mm-hmm.
Is that an account of profit?
No, it's the actual costs that you have billed during the restraint period to clients of your previous business. And that's how you could calculate it. So without saying in advance that you want 75% of people that she's dealt with in the last 12 months, that's one way of doing it. But I had I had a client recently who is an accountant, and they had somebody leave and start their own business and take a client list. Now, they didn't recover on the basis that they took the client list or approached people that they dealt with in the 12 months prior to leaving. They recovered because the clause said that she would pay to them the amount of damages that were calculated by the amount of money she received over the restraint period from the people who were clients of the previous firm. That is a valid calculation of your loss. And that's one way of doing it. And to me, it's the better way of doing it, because you're not trying to calculate something into the future that you don't really know whether it's going to happen or not. And you run the risk of being unreasonable if you do that. You know, the 110%, the 105%. Get it down to 75 might be reasonable. But, okay, that's one side of the coin. But the other side of the coin is you've earned money from clients that you've dealt with pre-sale of the business, and that money should be hers.
I think we should wind up.
I think we should wind it up too. There's still some left in the Shiraz.
Thank you, Robert.
Thank you. Thank you. Bye-bye.